Welcome to the Docketing Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective US-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman-Lundberg-Wüstner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are about 2 webinars per month through May 2017. To see a complete list of webinar topics and to register for future webinars, go to the Webinars tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 8th in the series. Today's topic is best practices and options for double docketing to reduce risk of missed dates. We have allowed time for questions at the end of the webinar. Questions may be submitted using the Q&A button on the control bar on your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. Today's presenters are myself and Shelley Cape. I am Ann McCracken, and give me 1 minute because I'm having a little technical difficulty. There we go, advancing the slides. I am Ann McCracken, the president of Black Hills IP. I am a patent attorney with 19 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Shelley, can you please introduce yourself?
Sure. My name is Shelley Cape. I am the Quality Control Manager at Black Hills IP. I've been with Black Hills IP for 3.5 years. Prior to that, I was the Docketing Manager at Schwegman, Lundberg, and Wüstner. And prior to that, I spent some time with Intelivate, setting up, they are an outsourcing docketing company, and I assisted them in setting up their docketing processes and their docketing training processes. I also have put in several years as a patent paralegal.
So it's interesting you mentioned Intelivate. Intelivate, wasn't that one of the very first companies to outsource intellectual property docketing as a business?
That I am aware of, yes.
That's great. Well, it's great that you're involved in that, and thank you for being a part of the program today. Today we're going to be talking about double docketing. Double docketing remains one of the best tools for risk mitigation in a docketing operation. This program will discuss the most common options for double docketing and how you can use it to avert catastrophic mistakes. Today we'll be discussing the scope of a backup docket or a double docket. And by scope, I mean what dates do you include on the docket? So what's the coverage of the backup docket? And then second, we'll talk about methodologies for a backup docket, and in particular, the logistics of tracking those dates that you decide to include on your backup docket. Before we get started, let's discuss a little terminology though. When I use the term backup docket or dual docket or double docket, I'm referring to having a system where you have two different sets of docket deadlines. One is a primary docket and one is a secondary docket. You're tracking dates in both of those systems and you're comparing them for purposes of making sure that you haven't missed anything on the primary docket. The other term that we'll use interchangeably is cross-off, completion, and D-docket. The term cross-off traditionally, for some of you will think of as referring to removing an item, literally crossing off an item from a paper docket book. We use that term interchangeably, though, with completions and D-docket, to refer to taking a date off a docket, whether it's an electronic or a paper, any kind of format for a docket. So let's get started with the discussion of what dates might be included on your dual docket. First, let's think about them in terms of categories of dates. Categories of docket dates and then the associated risk with those docket dates. One category of docket date is reminders. Another category of docket date is non-final deadlines. Both of those categories have minimal to no risk if they are missed or incorrectly docketed because, well, a reminder is just that, a reminder, and a non-final deadline is extendable, and if you miss that date, you can still file your item that needs to be filed. But moving from the minimal to no risk category to a category where you have some risk would be a recoverable final deadline where the PTO notifies the applicant that you have missed that deadline. So meaning you get a notice of abandonment, for example, even though you've missed the final deadline. There's minimal risk in this case because you can revive them, but it's still a deadline that you don't want to miss. So Shelley, can you give us some examples of recoverable final deadlines where you get a notice of abandonment?
Sure. In the US, obviously office actions, if you don't respond to a non-final or a final, you're going to receive a notice of abandonment. Appeal briefs not being filed, formalities like notice of missing parts, those kinds of things are documents where you will receive a notice of abandonment. In some of the foreign countries, you also will receive what we would call a notice of abandonment, EPO office action responses. If you don't respond, you're going to get a notice of loss of rights. In Canada, if you fail to file your request for exam, you will receive a notice of abandonment. In those countries, there are some differences in your response periods, but you do get the notice of abandonment and you do have the option to file and complete your date.
So in those examples, even if you missed that deadline, something would come to prompt you that you had missed it and that you could generally have time to take corrective action on them, correct?
Correct.
Okay, the next category then, which transitions from minimal to no risk to high risk, is recoverable deadlines where the PTO does not reliably or at all notify the applicant that a deadline was missed. So final deadlines where there's no notice of abandonment that comes if you miss it. Shelley, can you give us some examples of those?
The first thing that comes to mind is maintenance fees. If you fail to pay your maintenance fees, it's rare to get a notice that you have failed to pay it. Mm-hmm. And that holds true in the US and a lot of other foreign countries. There are some foreign countries that will send a notice, but not many. Also, the PTAB, the appeal board, if they affirm the examiner's rejection, you have 2 months to file some sort of action. And if you miss that 2 months, you are not going to get a notice of abandonment or any kind of notice at all.
You're just done.
You're just done.
So in those examples, if you miss that deadline, that's particularly high risk because unless for some reason you realize it, nothing from the patent office is going to come to trigger you that you missed the deadline and you need to take some kind of corrective action, right?
Correct.
But at least if for some reason you would figure out you missed it, you could in a period of time revive. So you still have that option in those examples that you just gave us. But the next category is non-recoverable deadlines where you can't revive if you missed that deadline. So can you give us a couple examples of what would be non-recoverable deadlines?
Bar dates. That's the first thing that comes to mind. Bar dates. Chapter 2 national stage deadlines. In some countries, you have an extra month or something, but if you miss that extended deadline, you're done. Mm-hmm. Direct filings off of based on Paris Convention, foreign filing deadlines, provisional conversions, those types of deadlines, If you miss them, they are non-recoverable. You can't get that date back.
So those are all very critical deadlines from the standpoint of docketing.
Yes.
Okay, now that we've talked about them from the kind of high-level categories, and you gave some specific examples, I want to focus on a few of those examples in particular that are particularly risky and vulnerable, and talk about how we could use the concept of double docketing to help reduce the risk of missing those deadlines. So we'll talk about individually the annuity and maintenance fee deadlines, the deadlines to file non-provisional applications claiming priority to provisionals, deadlines to file foreign applications or PCT applications, and then also a context that people might not think about for dual docketing is file transfers. Let's start with the annuity and maintenance fees. In the US and other countries, the owner of the patent often receives no notification that a payment has been missed. So there's no reliable backstop for this category of deadlines. Even if notice is provided, it's possible that it might go to the wrong party because many times the party responsible for the annuity or maintenance fees is different than the party that was responsible for the prosecution, and you have different correspondence contacts and it doesn't get forwarded. And in some countries, particularly Japan, for example, they're extremely unforgiving when it comes to recovering a missed date of this type. Or let's say the party has decided, has accidentally marked an item as dropped or don't pay in their docketing system. So it looks like they had intended to let it go abandoned. Even if they get some kind of a notice that the payment was missed, they might ignore it because they thought they hadn't planned to pay it. So there's all kinds of reasons why these are risky dates. Can you share with us why or how you could use the concept of a double docket to help reduce the risks in the annuity and maintenance fee deadlines?
Yes. The most apparent to me is using a third-party vendor for annuity payments. If they will track your deadlines in their system, and you can be tracking the deadlines in your system. A lot of times they are pulling the information out of your system in one way or another, but they also go, most of them will go to a little extra length in that they're checking, verifying the dates and information that's coming out of your first system against public data. So they're looking and verifying your dates. That can be used as a double docketing system. Mm-hmm. Those can be compared against each other. A key thing for using a dual docketing system is having the information entered into both systems, whatever it is that you're using, independently. And that verification that they go out and do is some of that independent entry. Other ways that you can do this is to, if you just simply have a paper docket or two electronic systems within your organization where information, again, is entered independently from the original source, so that data can be compared against each other to make sure that those annuity and maintenance fee deadlines are correct.
Okay. So if you're using a third-party vendor, that could be the primary docket for your annuity deadlines, and then you may, as a double docket, track in your own internal system, whether that's electronic or paper, the deadlines as your backup or dual docket, right?
Correct, yes.
Okay. And then just one thing to point out, you mentioned this to me when we were preparing for this program, that some of the annuity vendors have their own software that they have you utilize to pass the data to them. And you gave me a tip that I didn't know. In the CPI system, you have the option to turn on and off date launching. Can you explain that? What
right. If you're using in a firm that I used to work with, CPI was our backup docket, our secondary docket for critical deadlines.
So they had another electronic docket was their primary docket.
Correct.
And CPI was a backup docket.
Correct.
Okay.
We did not track the maintenance fee deadlines in the CPI docket.
Okay.
So we had them turn that off so that those dates did not launch when we entered information into the program.
So you had to use their system to get the data to them.
Correct.
They were tracking the data on their end in a system that you didn't actually see. And your dual docket was your the firm's primary docketing system, which was something other than CPI, right?
Correct, yes.
Okay. Okay, so that's a good tip. So people may not know that you can turn on or off the date launching using that CPI system. Let's go next to provisional conversion deadlines. Again, this is another example where the USPTO does not notify the applicant that a provisional has expired, so there's no USPTO backstop if you miss this deadline. Once you go beyond the 2-month grace period, there's no way to recover the original priority date if you've gone past that 14-month date, which is the end of the grace period. So any kind of accidental cross-off, for example, would have to be discovered either shortly before the 12-month deadline for converting the provisional or within that 2-month grace period, or there's no chance of keeping the original priority date. And you know, with provisionals, there's not a lot of USPTO communications that come out during the pendency of the provisional. So if the provisional does not get properly set up in your system or on your pair certificate, it's possible that the communications that you would normally use on a non-provisional application to prompt you to double check your docketing, you won't have those to check as a backstop to make sure you have your provisional docketed correctly. So again, for lots of reasons, a provisional conversion deadline, that 1-year date, that 12-month date, is a very risky date if it's docketed incorrectly, and that's a great candidate for dual docketing. So Shelley, can you talk about how to use dual docketing to reduce the risk of missing a provisional conversion date?
The key thing for any kind of dual docketing system is to have the data entered independently into separate systems so that the 12-month deadline is tracked in 2 places. And keep in mind that your second docket can be something as simple as a paralegal's paper docket with the non-provisional dates tracked manually, or the attorney adding it to his Outlook calendar. An organization doesn't have to have 2 electronic systems to have dual docketing in being used in their organization. The other thing is to make sure that when you cross off a deadline like this, a critical, non-recoverable deadline, that 2 different people are responsible for reviewing and crossing those dates off in the 2 systems. Okay. Again, they can review the instructions that you've received to make sure that they're clear and concise and you know what your customer or client wants. Mm-hmm. And if you've got 2 people looking at it, then your 2 systems are going to match up and meet the right deadlines or take the right deadlines off.
Okay, so for dual docketing purposes, it's key that you have independently entered data into these 2 different systems. And I say entered, but it's not necessarily an electronic system. It could be one electronic and one paper docket book, but adding the dates to be tracked separately by different people independently in those 2 different systems, and then also independently removing them so that you also don't have an error with an accidental cross-off of that date, right? Okay, those are good tips as well. Now let's talk about foreign filing deadlines. Again, with respect to a foreign filing deadline, you get no notification from the Patent Office that a foreign filing deadline is approaching, so there's no USPTO backstop. Once you go over the 1-year foreign filing deadline, there's no way to recover foreign filing rights in most countries. So an accidental cross-off would have to be discovered before that 1-year foreign filing deadline, or you have no chance to foreign file off that original priority date. That right is lost. And foreign filing deadlines for the Asian countries have to take into account time zones as well. So if you are on the last day in the US, you may have already missed your deadline. So for these and other reasons, the foreign filing deadlines are particularly risky as well. Shelley, can you first explain the process that you used in your previous firm to double docket foreign filing deadlines?
Yes, and I will say that the foreign filing deadlines were basically the same as our provisional deadlines, so they kind of mimicked each other. The information about the file itself, especially the priority information, was independently entered into Foundation IP, which was our main docketing system. It was independently entered by a second person into our backup system, which was CPI, and the foreign filing deadlines would launch in both systems. So we would have it in two places. We would run a report out of CPI on a weekly basis for the next 7 days. And we would compare the dates that showed up in CPI with the dates that showed up in Foundation IP, looking for where there could be or would be discrepancies, so that we would know if something seemed off. And we did that on a weekly basis. It helped us also kind of watch the cross-off situation, because if the date showed up in one system and didn't show up in the other system, it would tell us that something was off and we would need to look. This was done, as I said, on a weekly basis for all of our critical deadlines.
Okay. So you were, at least at the time you were at that firm, you were using your dual docket system to track, to make sure the deadline itself was added correctly to the docket. Could you also use this type of a process to make sure the deadline was correctly removed from the docket?
Yes, yes. Obviously, if it was incorrectly removed from one system, it would show up in one and not in the other. So we would know that something had happened. Sometimes in the firm that I worked with, the paralegals were responsible for crossing off the dates in Foundation IP, but they needed to let us know that information. So if we didn't get it, it wouldn't be crossed off in the CPI system.
Okay.
And then we could investigate that.
Okay.
There are some other ways that you can do this. I mean, not every organization can have two electronic systems. We could be comparing the dates in our main docketing system to what the paralegals have in their docket book, sending out a report regularly. Here are the critical deadlines for the next 2 weeks. Check them against your docket books. There are a lot of ways that it can be done that way. There are places that have their secondary docket, or I mean, I can see this working with things like companies using Black Hills IP as their secondary docket as well. The secondary docket doesn't necessarily have to be on site to be effective.
Well, and that's a great comment with respect to Black Hills IP. Black Hills IP might be the secondary docket, or if they view Black Hills IP as the primary docket, then they should have some kind of a secondary backup docket for critical deadlines on their side as well, right?
Right, right.
Great. So these are all very good practices. Let's talk about an example that people might not normally think of when they're discussing backup dockets, but it certainly applies, and that would be the file transfer example. So file transfers are very risky for several reasons. First of all, files can fall through the cracks and not get entered onto the new docket at all. Second, the dates that are time sensitive might not get added to the new docket soon enough to take timely action. If there are notices of abandonment, unfortunately, that happen, those are sometimes sent to the old correspondence address, particularly if the powers haven't been updated yet and not received by new counsel. And files are often received in multiple file formats and are not necessarily docketed properly to begin with. And then there's just the overall time crunch issue when you have many files to be transferred in all at once. And Shelley, I know in your experience, you've worked on file transfers with literally thousands of files all coming in at once. So this is a different way to use the concept of a backup docket or a dual docket, but can you talk about how you would utilize a dual docket process to reduce the risk in the file transfer process?
The first and most important thing is to make sure that you get a fairly long-term, 3 to 6 month at least, docket from the previous counsel. Obviously, you don't have those files in your system. You have no idea what's coming due. So that docket report from previous counsel becomes your main docket. Then during the process of setting up the files in your system, you can run reports to verify that you're getting all of the dates that are on that docket report entered in a timely fashion. In all the processes that I've been involved with, once the files have been set up in the main docketing system, they've been passed on to the paralegal for paralegal review, and they will then enter dates that are due into their paper dockets. Again, reports can be run out of the main docket system to check against what the paralegals have entered, but normally that's only within say a 1-year time frame. Their paper dockets aren't going to go, say, a request for exam that's due 3 years from when you're entering it into the system. So it would be a really good idea, as far as the dual docketing thing, to make sure that the paralegals have a copy of that original docket from previous counsel, because then they can be checking, as they're looking independently at that file, they can be checking against that docket that you received. Again, it may not have, if it's only 3 to 6 months, it may not have that request for exam deadline that's due in 3 months or 3 years, but they are looking at it against that and against your main docketing system, comparing to their paper docket system.
Okay.
Other ways to use this is the files can be, if you're independently entering them into 2 electronic systems, you can pass it to your next docketing person that's putting it into that system. Then you run reports and compare them against the two different systems. But the most important thing is to make sure that you get a docket report from previous counsel, so that you know what you're working with and can be efficient in what you're doing.
So in the context of file transfers, you can think of the new counsel's primary docket as the primary docket. And then from a backup docket perspective, you may be using the prior counsel's docket that they gave you as a backup docket, or the paralegal docket as they're starting to add things to their docket as a backup docket. So certainly the concept of having deadlines on multiple dockets as you go through the file transfer process will help you with reducing some of the risks that are there in transferring files, right?
Correct. Correct.
So I have a question for you, Shelley, now that I've been listening to this. If somebody's going to start using a dual docket process, then they're not right now. This goes back to that question of scope, what do you put on the docket? We've talked a lot about a lot of different types of dates. We talked about some very specific types of documents. Do you put everything on your backup docket? Reminders, recoverable dates, non-recoverable dates? Do you only put certain dates on your backup docket? How much should they put on the docket?
I think the first thing that you need to know is, what is the risk tolerance of your organization?
Mm-hmm.
And what is the oh, I can't think of the word I want to use. That's horrible.
Malpractice.
Malpractice. How is your malpractice insurance set up for double docketing or dual docketing? You need to follow what they have set out. That's the first thing you need to know. But second of all, my personal opinion is that you don't want to put everything on your second docket.
Mm-hmm.
There's too much noise with that. If it's only the critical non-recoverable deadlines, people will pay closer attention to what's on that secondary docket.
Mm-hmm.
And it will be more, it will also be easier to search, it will be easier to compare, it just will take a lot less time. You don't want to take the time to enter all of those dates
Mm-hmm.
onto that secondary docket. So basically, you need to know what's the risk tolerance for your organization,
Mm-hmm.
and then how much noise do you want to actually be dealing with on a daily or weekly basis when you're comparing those two dockets.
Okay, and that probably also translates to resources. How much do you have for resources
Right.
to enter it and track it as well, right?
Right.
Well, that's really helpful. I appreciate that insight. Let's now talk about methodologies. We've talked about the scope of what you cover on a dual docket. Now let's talk about how you go about tracking those dates. And you've already gave some suggestions about it could be two electronic systems, it could be an electronic system and a paper docket system. There's lots of different ways to implement the idea of a dual docket. So one of the most common methodologies, I would say, for law firms is to have a single electronic docket system. There's lots of them out there. It might be CPI, Memotech, Anaqua, Foundation IP, IP Manager, whatever your docketing system is as your primary docket, and then have the dual docket or the backup docket kept by a paralegal. And can you explain how that process would work with a primary docketing system and then the paralegal tracking dates as a secondary docket? How do you implement that?
Generally, a document is received from the PTO or from a foreign agent, and it goes through the docketing department so that it can get added to the main docketing system. It is then forwarded on to the paralegal so that the paralegal can independently take a look at the document and enter the due dates into his or her paper docket. They then, as far as some companies that I've worked with, send out routinely on a either weekly or monthly basis a report out of the main docketing system for the paralegal to compare to their docket book to make sure that the dates are matching up.
Okay. So for this process to be effective as a dual docket system, you said independent. It sounds like it's critical that the paralegal must independently determine the date and calculate it themselves in the system that they're using to track. They can't just copy the date that they see in the primary docket system and put that into their own docket, right?
Correct.
They need to make an independent determination. So provided that you have a very knowledgeable and skilled paralegal, and that paralegal is independently determining the date to put on the backup docket, this can be an effective risk reduction methodology, right?
It could, yes.
Okay, let's talk about another methodology. This would be to have two different electronic docketing systems in the same, well, I say in the same organization, but it wouldn't necessarily have to be. It could be an organization and a vendor such as Black Hills IP. But let's say it's two different docketing systems in a single organization like you had at the law firm that you were working in. Can you talk about how that worked?
Yes. When I was at Schwegman, our primary docket system was Foundation IP. Our backup system was CPI. We only tracked non-recoverable deadlines in the CPI system. The information would be added into Foundation IP. It would be entered into CPI by a second person not involved with Foundation IP. Then reports would be run to compare the data for those critical non-recoverable deadlines. We never crossed anything off in CPI. We weren't using it. We weren't dual docketing our cross-offs as such. So the dates just stayed there in CPI. We didn't feel we had to clean it up.
Okay, so that type of a process, two different docketing systems independently calculating the dates, is, again, a very effective methodology for reducing your risk on those critical dates. Now, you said, though, that you weren't crossing dates off in that particular example, but let's say we wanted to also implement a dual docketing process for cross-offs. Can you talk about how you could implement something like that?
Sure. You could have two different docketers looking at the cross-off information, say a junior docketer and a senior level docketer, but at least two separate people looking at the cross-off information and being responsible for crossing it off in one of the two systems. This could also be, if your second docketing system is a paper docket, say the paralegal's docketing, or docket book, you've got the docketer crossing it off, you've got the paralegal crossing it off. Again, two separate sets of eyes. And finally, if an attorney is, say, tracking some of these dates, say in their Outlook calendar, they're entering non-provisional deadlines. Again, the attorney is crossing it off of his, the docketer is crossing it off of theirs. There can be some reports that are run to confirm that those dates have both been removed from both systems, which you would then believe to be correctly crossed off. If it showed up in one and didn't show up in the other, you have to do some investigation. But in my experience, I haven't been involved in a situation where dual docketing has been done for cross-offs. I think it's a great idea because these dates that we're talking about are non-recoverable. And sometimes customer or client instructions aren't clear, or you get them at the very last date, at the very last time. It sounds like a very sound thing to do, to have dual docketing for cross-offs. Well, I agree. It is a great idea from a risk management standpoint. And those are the kinds of things that we focus on Black Hills IP, because we need to be able to sleep at night here. Just one last comment on dual docketing for cross-offs. This would be building on the example you just gave, where you have two different people removing the date from two different systems respectively. If you wanted an added level of verification on that, you could have a process where the client then confirms that the item that was removed was actually something that they had wanted to be removed. And there's lots of ways to do that. It could be through an email notification to a client. It could be through some kind of a portal where they log in and verify the items that were updated on the docket. Lots of ways to implement it, just throwing the idea out there for purposes of discussion. So today we have talked about docketing and dual docketing processes, both from the standpoint of how much to cover and what things to cover for dual docketing, and then how to implement and track the dates that you're going to dual docket. At this point, we have time to take questions from the audience. You can submit questions using the Q&A button at the bottom control bar on your screen.
and we'll give people a minute to enter questions if they have any questions. And I also want to remind people that the slides and an audio recording of today's program will be posted on the Black Hills IP website in a few days, so you can always go back and look at this program or earlier programs that we've had in this series. So let's see what we have for questions. The question that was submitted here is, how do you enter information into your own docketing system? Manually or automatic transfer? Is the data verification done manually or automatically? And can you automatically verify with public registers? So there's a lot of questions in that one question.
There are.
And I'm assuming that you, I guess that's meaning Black Hills IP. So how do we enter information in our docketing system? For USPTO data, we're able to pull that directly from the USPTO itself, so then we can pull that and enter it into some docketing systems that have an interface that we can talk to electronically. And then the data verification part of the process, and I assume that that means second set of eyes review, the reviewing of the docketing dates into the system. Again, so for Black Hills IP, is that done manually or automatically? We have some automated methods to do data verification, and those are a key part of our quality control processes. And then, Shelley, do you want to add anything to that question?
With one of the systems that we do use, most of our docketing is entered manually. It's not automatically. However, we do work with one system that scrapes PTO or trademark information, and that is actually added automatically.
Oh, yeah, that's right.
So I guess we do it both ways.
Okay. Let's see what else we have for questions. How many systems does Black Hills IP work with? Shelley, I'm gonna...
Oh, wow.
There's a lot, right?
There are. We work with Foundation IP, IP Master and IP Manager, Memotech, AppCall. What else am I? CPI.
CPI. Those are some of the main ones. There's probably a few others, but on any given day, we are working in all the primary.
Yeah, 6 or 7 different. We did work in and can work in Anaqua.
Mm-hmm.
Yeah, I think that. So 6 or 7 main systems.
So then a follow-up from this listener is, why so many systems?
Well, different customers. Different customers have different systems, and they want us to docket in their system rather than our own system. So we obviously do what our customers ask us to do.
So we can do both, right? We
Exactly.
use an internal system for a customer that doesn't have a docketing system, or docket remotely into somebody's system, as long as it's easily accessible.
Correct. Right? Correct.
Okay. All right. Shoot, I'm trying to keep track of these questions. We're getting lots of questions. So with the manual double docket, what happens when there is a power outage? What do you rely on? So I'm trying to follow that with the manual double docket, because it seems like if it was manual, I'm interpreting one of those to be like a paper docket book, but maybe I'm not reading this question right. Shelley, how do you read that?
Well, this is a really good question that's been asked in a lot of places that I've worked.
Oh, okay.
Lately, as technology has come to where it is today, and it probably within the last 10 years, there are ways to run reports so that you have them, the power outage is today, you want to check your final deadlines for today. the report would have been run yesterday. So again, we're talking about a double docket. In that situation where you have the report, you've been proactive and you've thought about this, you've still got your two systems. You can look at the report that was run yesterday, you can talk to your paralegal, look at their paper docket. If you've got a power outage and you don't have access to your electronic system, the only thing you do have is the paper docket, as well as the paralegal's experience and expertise. They know what they need to do, and generally they're really on top of things.
Those are some really great practice tips there. That was a really good question. So there were a couple other questions, and I'm just going to generalize them here about some other systems that we didn't name and whether or not we work in them. And we have a number, our docketing staff is very experienced. You've heard many of them talk on previous webinars, and even if we're not working in a particular system today, it's very possible that a person on our staff has worked in that system, maybe in a previous position that they've been in. So we'd be happy to talk with anybody about particular systems and our experience. With regard to multiple systems, your customers need to allow you to enter their database, and your paralegals need to train to understand the individual systems. That's a fair statement. How do you handle this? Well, again, so when we have people with experience in a lot of these different systems, but then we have a lot of tools internally that assist our docketers as well with the docketing process, so that we make sure that whether we're docketing into a CPI or a NACWA or a foundation IP, we know that for that particular system, we're following the rules and the instructions for the customer, because maybe an office action docketed in one system is still an office action and it has the same due date, but it may have a different template or task or activity, whether it's in foundation IP or a NACWA. So we have systems internally that we have to help confirm that our docketers are following the right process. But it starts with having a very skilled set of docketers to begin with and a good knowledge base. Okay, let's see what we have left. Okay, does Black Hills IP assign unique identifiers when docketing?
Yes, we do. I'm assuming what that means is, can we track who did the docketing? That's, I guess, the assumption I make, and yes, we do.
So from a quality control standpoint,
exactly.
Whether you were docketing into the primary system or a secondary system or whoever we were docketing for, we have a way to identify who did it and what they did.
Yes.
Okay. Then, here's the clarification, unique identifiers as reference numbers.
Well, that all depends on what system we're working in and what our customers require for their system. If we're working in their system, we have to follow what they do as far as reference numbers. The docketing that we do for our customers that they don't have their own system, we have a system that we use for them. Yes, there are unique identifiers. Our system does not allow for duplicates.
Okay, so this may be a follow-on to that question. So if client-specific instructions, such as a request for a proposed response by a certain date, are not tracked in the main docket system, would it not be important that this date be entered, tracked, and crossed off in the secondary independent docket? So if the instructions are not tracked in the main docket, but they have to be entered, tracked, and crossed off in the secondary docket.
I think that depends on the organization. In a couple of places where I've worked, the paralegals understand their customer or their client specifics. And those dates I can see this happening, say, with a client that is a corporation and you are their outside counsel.
Mm-hmm.
You know that corporation wants a proposed response. You get an office action, your 3-month deadline is tomorrow. They want a draft response a week ago.
Mm-hmm.
I think a lot of places, the paralegals put that on their paper docket, which would be a secondary docket depending on the organization that you're in.
Mm-hmm.
I know some systems can be set up so that it is tracked in the main system, depending on the template that's used or the code that's used to docket that office action or whatever it is that you're docketing. It can launch those dates in the main docket. But if it's not in the main docket because you're only tracking true deadlines,
mm-hmm.
it could be in a secondary docket, and I've seen that happen in numerous situations.
So you just need to have the processes in place to make sure that those are independently being taken off whatever is covered on each of those dockets.
Right.
And it's a good point. Your primary docket could have more dates than your secondary backup docket, right? The secondary backup docket could be a minimal list of docket dates. So you can have those be different. All right. I'm getting close to being at the end of our time. So Shelley, one last question. This goes to something I think you talked about earlier. Is it critical that the secondary docket dates be crossed off as well as the first docket? And you've got experience where you didn't. You just left them on,
we
right?
We just left them on. They were only there for comparison reasons, and we didn't put the resources towards cleaning that docket up.
Mm-hmm.
If you had other reasons for that secondary docket that you maybe did some other things out of, you might want to do it, but no, I don't think it needs to be done.
Really depends on what you're using that secondary docket system for.
Yes.
If you're using it just to have an independent set of country law, independently calculating the due date and comparing that to the due date that's calculated by the first system. So you're making sure the calculations are correct, and then you're also making sure that the data entry that triggered those calculations are correct, and that's all you're trying to do. Doesn't matter if you take it off, right?
Correct.
Which is an interesting concept. But then if you also are wanting to go to the next level, which, as you said, you don't see this very often, but for really true risk reduction, it's a great idea to cross off in both of those systems, because you can compare those as well.
Yes.
And then you have a true full, I would say, dual docket system.
Yeah.
When you're doing both the add on the docket and the cross off part of the process. Okay. I'd say that I didn't think we'd have as many questions as we did, but these have been great questions. And if there's any questions that anybody would like to ask as a follow-up after this, please feel free to contact us. The next webinar in the Docketing Excellence webinar series is January 25th at 1 p.m. Central. The topic is Top 3 Vulnerabilities in the Annuity Docketing Process. Annuity docketing errors are renowned for exposing law firms to extreme liability, but these errors usually don't occur where one would expect. In this next webinar, we'll talk about the sources of the most serious annuity docketing errors and how to avoid them. To register for this webinar, go to the Black Hills IP website. Thank you for participating today. We hope you will join us for this and other webinars in the Docketing Excellence webinar series.